Hi, I'm Jaspreet on this side. I'm company secretary by profession. So we are continuing with our summary of Companies Act 2013. Intent is to have a summary, have a quick run through all the provisions of the Companies Act, and I am using this notebook Saransh by ICAI. I find it very helpful because it has graphical presentation of all the relevant and important information. So everything in a good graphical format. So let's proceed. Last in our first video we have already covered the definition of company, and in the types of company we have covered companies on the basis of limitations, limited company, private limited company, limited by guarantee, unlimited company. Then on the basis of members, on the basis of members is private company, public company, one person company. And now we are proceeding further with on the basis of control. So now we proceed with on the basis of control. So on the basis of control of a company, we have companies as holding company or a subsidiary company. Holding company. Holding company in relation to one or more other companies means a company of which such companies are subsidiary companies. So in the definition of holding company in section 2 subsection 46, it only describes passively as a company which has subsidiary. So when we understand the definition of subsidiary, we will get figure out the definition of holding company. Subsidiary company as defined in section 2 subsection 87 means a company in which holding company controls the composition of the board of directors. So the board of directors is controlled. Number two, exercises or controls more than one half of the total voting power, either at its own or together with one or more of other subsidiaries. So first is that it controls composition of board. Second, it exercises or control more than one half of the total voting power. More than one half means if a company is holding 50% shares in other company, then will that company be a holding company? If a company holds exact 50% equity stake in another company, then will that company be a holding company? The answer is no. And this is one part. Another part is there is an or provision controls composition of board. There can be an agreement among companies whereby one company has control over the composition of board. Means board cannot be changed, directors cannot be changed without the concurrence of this other company. So in a way it is controlling the board. So in these ways a company becomes a subsidiary to another company. Now exercises or controls more than one half of the total voting power. Words used are not equity shares. Words used are voting power. Means at the time of votes, it has power to vote, and that power is more than 50%. Plus, does it require to hold that voting power on its own alone? No. Either on its own or together with one or more of its subsidiaries companies. So means either having voting power more than one half singly or together with any other subsidiary company. So other company should be subsidiary company. If two companies are holding more than 50% shares, but the other company is not a subsidiary, then it will not qualify to become a holding company. However, prescribed classes or classes of holding companies shall not have layers of subsidiaries beyond such numbers as may be prescribed. So there are certain classes of holding companies which may not have layers of subsidiaries. So there is a limitation on number of layers of subsidiaries. Certain investment companies can have only two layers of further investment companies that will come later. So here there are certain prescribed classes of holding companies that will not have more than certain layers of subsidiaries. Next is layer, means holding under that one subsidiary, under that another subsidiary, under that another subsidiary. So these becomes layers. So I think it's clear. Holding company, under that subsidiary company, under that subsidiary company, under that subsidiary company. So these are layers. Layers. Okay. Next is associate company. Now, associate company, section 2, subsection 6 defines associate company in relation to another company. So means an associate company will be understood only in relation to another company. So in relation to another company means a company in which that other company has a significant influence, but which is not a subsidiary company of a company having such influence and includes a joint venture company. So if it is a JV company, then already it is falling in the definition of an associate. Second requirement is that there is significant influence. However, there is no control of composition of board. There is no control of more than half of the voting rights. So then this company qualifies to be termed as associate company in relation to this another company. Now words used here is significant influence. Significant influence means, what is significant influence? Significant influence means control of at least 20% of total voting power, or control of or participation in business decisions under an agreement. So significant influence means either the control of at least dash voting power. How much voting power? Control of at least 20% of total voting power. 20% of total voting power. Okay, with total voting power means not only those who are present in the meeting and voting, but all the members included. Or other condition can be for exercising significant influence, control of or participation in business decisions under an agreement. There is an agreement where you have control in business decisions, or where your participation is required in business decisions. There are certain decisions relating to business which require your concurrence, your involvement, okay, or require your approval, consent, require your participation. So if these conditions are fulfilled, then a company will qualify to be an associate company under section 2 subsection 6. Now another one word is joint venture. Joint venture company. So joint venture company is an associate company. Joint venture means a joint arrangement whereby the parties that have joint control of the arrangement have rights to the net assets of the arrangement. So here, earlier we had restricted definition of joint venture under Companies Act 1956, but now under 2013 Act, the definition has widened in its scope. JV is a joint arrangement. It is a joint arrangement whereby parties that have joint control of the arrangement. So this is an arrangement. This may be in a form of a specific company. However, this is an arrangement where parties have joint control of the arrangement, have rights to the net assets of the arrangement. This is an important word. This word distinguishes a joint venture in the New Companies Act. So it is a joint arrangement where control is joint of what? Net assets. So if assets, net assets are controlled jointly, then it is a JV. But for qualifying as an associate, JV must be in a form of a company. So JV company. So JV can be a company, JV cannot be a company. But to qualify as an associate company, JV must be in a form of a company. Next is total voting power. Now, in relation to any matter, total voting power in relation to any matter means The total number of votes which may be cast in regard to that matter on a poll at a meeting of the company if all the members thereto or their proxies having a right to vote on that matter are present at the meeting and cast their votes. Total voting power means total number of votes which may be cast in regard to that matter on the poll at a meeting. So we are focusing on total number of votes cast by a poll, okay, on the matter on a poll. If a poll is conducted, then total number of votes will be which will be casted on that matter at a meeting if all the members thereto or their proxies have the right to vote on that matter are present at the meeting. So we assume that suppose in a meeting all the members are present and all choose to cast a poll at a meeting either themselves or through proxy, then that will be termed as total voting power. So total from the total voting power, if a company has at least 20% of control, at least 20% means there is a company which has, now is it word at least? Yes, it is the word at least. At least 20 means if a company has exact 20% of total voting power, then this company becomes that company's associate company. Okay, this company becomes that company's associate company. What will we call that company? That company can be called as an investment company. So associate company is in context of investment company. Okay, so these were companies on the basis of control: holding subsidiary and associate. On the basis of control, a company can be either holding subsidiary or an associate. Next is on the basis of access to capital. So on the basis of access to capital, a company can be listed company or an unlisted company. Listed company is defined in section 2 subsection 52. Listed company which has any of its securities listed on any recognized stock exchange. So earlier number of stock exchanges which were recognized were higher, now the number has reduced. So it is important that it has its securities listed on a recognized stock exchange. Here, such class of companies which have listed or intend to list such class of securities as may be prescribed in consultation with the SEBI shall not be considered as listed company. So there can be a class of company which have listed or intend to be listed as may be prescribed in consultation with SEBI shall not be considered as listed company. So what I find is that there are many ifs and buts in the process. So whenever we try to jump on a straight yes or no, we have to linger on with additional questions. Okay, additional questions will help us understand every time practically when we are in a situation. So we have our knee jerk reaction that this can be done, this cannot be done. However, if we will open the section relevant law and start reading, then we will figure out all the ifs and buts which need to be complied in order to come to a clear yes or no. So usually I try to say things in a positive way like yes, this can be done provided these terms and conditions are fulfilled. So anything can be done provided these terms and conditions are fulfilled. So a company can be listed, yes, if its securities are listed on a stock exchange, recognized stock exchange. Howsoever, still a company may not be termed as listed company. Okay, if it is prescribed in consultation with SEBI as not a listed company, there can be a possibility. Unlisted company. Unlisted company means company other than listed company. So just as holding was other than a subsidiary. Similarly, unlisted is other than listed company. I think that is clear. Usually companies start off as unlisted company, then they may get themselves listed. And since private company cannot offer shares to public, so a company will be either a public company or it will be converted into a public company. Next is uh, other companies. Other companies, there can be other types of companies. So on the basis of members, on the basis of liability, on the basis of control, so on the basis of listing. Okay, now other is other companies is government company. So government company is defined in section 2 subsection 45. What is the requirement? The requirement is that at least 51% of paid up share capital is held by. So here it is not more than 50%, it is at least 51. So it cannot be 50.5, 50.6. It has to be 51% shares at least are held by who? Central government or any state government, or partly by central government and partly by state government, or partly by central government and partly by more than one state government. Central government, state government, and central government partly by one or more state governments. Central government and one or more state governments. At least 51% shares are held by them. Here, the paid up capital shall be construed as total voting power, where shares with differential voting rights have been issued. So, if it is a case that shares with differential voting rights are also issued, then for the purpose of paid up capital, we will construe as total voting power. Further, this includes a company which is a subsidiary company of such government company. So, subsidiary company is also deemed to be a government company. All the subsidiary companies of government company are government companies. Next other types of companies is small company. So section 2 subsection 85 provides a definition of small company. A small company is a private company. It should be very clear that this is different from MSME. That small company definition is different in MSME and this small company definition is different in Companies Act. Both need not be confused. So here small company means it should be a private company. It should have a paid up capital not more than 4 crore or such higher amount as may be prescribed, which shall not be more than 10 crore rupees. So small company, private company, and paid up capital not more than 4 crores or such higher amount as may be prescribed. So this 4 crore is also on the basis of higher prescribed amount. So in law we will find that primarily it is written 2 crores or such higher amount or something else, but this 4 came based on present notification. This is presently prescribed 4 crores of paid up capital, and this is the maximum limit. If not more than means if it is 4 crores, paid up capital is rupees 4 crore, then it is small company if it qualifies other condition also. Not more than 4 crores or such other higher prescribed. But that higher prescription cannot exceed 10 crores. Okay. And turnover. Turnover as per P&L account of immediate preceding financial year. Here it is written immediate preceding financial year. It may be that financial year has ended, however, audit is not yet completed. But we have to take turnover of the previous financial year, immediate previous financial year. So turnover is not more than 40 crores or such higher amount as may be prescribed, which shall not be more than 100 crore rupees. Earlier this 40 crore was 20 crore. This may fluctuate up to 100 crores. So for a small company, there are three things which we need to observe. Private company, it is a private company. Paid up capital, 4 crores, up to 4 crores. Then turnover up to 40 crores. Turnover is based on immediately previous financial year figures, which may not be audited as on the time we are considering. Now, it needs to be understood that if it is a Section 8 company, then it cannot be a small company. If it is a holding or subsidiary company, then it cannot be a small company. A company or body corporate governed by any special act. So if any special act applies to it, then it is not a small company. Okay. So holding and subsidiary, usually it happens is, especially in real estate sector, that there is a holding company and there are many subsidiary companies. So the subsidiary companies may have nil paid up capital or only 1 lakh paid up capital, but even holding company may not have sufficient required paid up capital and turnover. Still, it will not qualify to be a small company because of that holding subsidiary relationship. And if we have registered a company as Section 8 company, then also it will not qualify to be a subsidiary company. Next is foreign company, Section 2, subsection 42. What is a foreign company? Any company or body corporated, any company or body corporate incorporated outside India. So it is incorporated not in India, outside India. Incorporation is outside India, which has, but it has a place of business in India. Okay, has a place of business in India, whether by itself or through an agent, physically or through electronic mode. So it has place of business in India, either by itself or through an agent, physically or through electronic mode, and conducts any business activity in India in any other manner. So conduct of business in India is important. If it conducts business in India, okay, it's any business activities happening in India. But here we have to see the word and. So there is requirement that both these conditions need to be fulfilled. Conducting business in India but do not have a place of business in India, then it will not qualify as foreign company. So having a place of business in India but has not started conducting any business in India, then it will also not qualify as foreign company. Have place of business in India and conducts business in India. It can have place of business either itself or through an agent. This will be termed as foreign company. Now, next is formation of companies with charitable objects, that is Section 8 companies. Section 8 companies have charitable objects. Now, Section 8 companies are formed for the promotion of commerce, art, science, religion, charity, protection of environment, sports, etc. So, etc. adds the layer that something similar. Okay, but intent is that we do not intend to earn profit out of it. Okay, we want to promote commerce, we want to promote art, we want to promote science, we want to promote religion, we want to promote charity, we want to protect environment, we want to do some sports, but we do not want to profit from it. Okay, Section 8 companies uses its profits for the promotion of the objective for which formed. It uses its profits for the promotion of the object for which it is formed. Does not declare dividend. So it do not declare dividend to its members. Dividend is declared out of profits. When it is not for profit company, then how can it declare dividend? Operates under a special license from central government. So after incorporation, we have to obtain a special license from central government to register our company as a Section 8 company. Need not use the word limited or private limited in its name. So it need not use the word limited or private limited in its name and adopts a more suitable name such as club, chamber of commerce, etc. It enjoys same privileges and obligations as of a limited company. So it has similar privileges and obligations as of a limited company. Then Section 8 companies, license revoked. License can be revoked if conditions contravene. If it is found that it is contravening any of the conditions of a Section 8 company under which a special license is granted to it by the government, then the license can be revoked. Can call its general meeting by giving a clear 14 days notice instead of 12. So it can call its general meeting by giving lesser notice, 14 days notice. With word clear we can add 3 days. 14 plus 3, 17 days notice. Requirement of minimum number of directors, independent directors, etc. does not apply. So it do not require minimum number of directors, means its director can be only one also. There is no requirement of minimum number of directors. Then independent director, it need not have an independent director, and such other similar requirements are not applicable to a Section 8 company which is formed for a charitable purpose and its profits are utilized for promotion of its object, which can be relating to art, science, commerce, religion, okay, charity, sports, etc. So here we have completed our different types of companies. Today we have covered on the basis of control, holding subsidiary and associate. Associate means 20% or JV, and holding subsidiary more than one half of total voting power or controls composition of board of directors on the basis of access to capital, listed, unlisted, and even certain listed companies may be termed not as listed company. Okay, there may be a prescription by central government in consultation with SEBI. Then government companies, 51%, at least 51% holding is with central government or with along with other state governments. Small company, private company, paid up capital 4 crores up to 4 crores, turnover up to 40 crores, and it should not be holding subsidiary, it should not be Section 8 company, and it should not be a company incorporated under special act. Foreign company which is incorporated outside India but complies to conditions that it conducts business in India and has a place of profit, a place of business in India, either on its own or through an agent. Then charitable objects, Section 8 companies for promotion of commerce, art, science, religion, charity, protection of environment, sports, and profits are used for promotion of objects, do not declare dividend to its members, can waive use of word limited, unlimited, and can have words club, chamber of commerce, etc. So it can give 14 days clear notice for calling its general meetings. Okay, so here we have covered this much. Next, in our next session, we will start off with Nidhi company and dormant company. Nidhi company, dormant company, and then memorandum. So this we will cover in our next video. All the best. You can write your comments. If there's any change in whatsoever I have spoken, then it will be added in the description box. So you can check the description of this video along. And there is a disclaimer that this is only for the purpose of revision, for better understanding, better grasp, to have a run through. That is the whole object of this video. All the best. Take care.